I've been practicing law since 1974, so if you can do the math, it's almost 40 years, ergo the lack of hair. And I've had a lot of experience over the years in dealing with the making of wills and powers of attorney, and dealing with estates, and dealing with some of the difficulties that arise for elderly folks. Powers of attorney are very important, and there's two types of powers of attorney. One is personal care, and that's very much limited to dealing with a situation where someone is in some care facility. It deals with health, nutrition, food, clothing, hygiene, the types of things that people need to be dealt with when they're in some type of institution. And that's a fairly new power of attorney. It's only been in existence since the early 90s. And it was brought into place for the very reason that we're here today, and that is many of the elderly were being abused in different fashions in some type of care facility when they were at a point where they could no longer care for themselves. So that type of power of attorney is, as I say, relatively new. The other type of power of attorney has been around for a long period of time, and that's the power of attorney for property and finance, the standard power of attorney where you deal with taking care of someone's property and finance and everything else involved in their lives. Something I want to make note of right from the beginning, an attorney, when we say power of attorney, attorney is not a lawyer. In the British system, which we adopted, an attorney is someone appointed to manage your affairs. In America and the States, they tend to interchange attorney and lawyer. So it doesn't mean a lawyer, it means someone that you've appointed to take care of either your property and finance or to take care of you. Powers of attorney are very valuable, but you have to watch out. And the type of abuse that can take place with a power of attorney is the person appointed can act as yourself. They can sign anything on your behalf. They can obligate you. They can contract for you. So once the power of attorney is given, it's a very helpful tool for most people, but it is open to abuse, and I've seen that happen. The best practice and advice I give to people is that they should appoint 2 or more attorneys and appoint them jointly. I don't know if you've seen that expression or the term that's in a lot of these documents where you can appoint someone jointly or severally. So often what happens in the standard situation is an elderly person has 3 children. They don't want to offend anyone, so they appoint all 3 as the attorneys, but 2 of them live locally, 1 lives somewhere else that's far away, and they feel they have to appoint them anyhow, and they say, well, let's appoint them jointly or severally, meaning that any one of the 3 can act, or they can all act together. Sounds democratic, sounds good, but it's also open to abuse, because what it can mean is that one of the persons appointed can sign the name of the person giving the power of attorney, can contract for them, can go to the bank, withdraw funds. All of those things can happen. So the best practice and advice I have for the elderly is to appoint 2 powers of attorney, 2 attorneys to be your powers of attorney, and that they be appointed to act jointly. So they have to act together. Now, in making of both wills and powers of attorney, you have to, and you should always know, either for yourself or if you're advising someone, a loved one who's older, that when you go to see a lawyer, that lawyer is acting for you, not for the family, not for the children. The lawyer is acting for you. And that lawyer should always interview the person alone, not with the family member in the room. It seems obvious why, but the lawyer needs to give advice to that person And that person needs to be able to be open and free with the lawyer as to what their concerns might be with regard to some of their children, and might feel inhibited in making that kind of statement with one of the children sitting there in the room with the lawyer. And again, I'm talking about a lawyer and getting advice from a lawyer. You don't need us. You can get on the internet and you can get all this advice free. You can get wills on the internet free, and you can get powers of attorney on the internet free. And when I give these seminars, I've done this quite often at Fanshawe College. I actually went out and bought one of those, $25 will kits. And I got a real kick out of it because the first 2.5 pages were a disclaimer written by a lawyer. So go ahead and use this, but don't sue us. And I always say I should end the discussion right now and say, go out and get those free will kits and those free power of attorney kits, because you'll mess it up, and I get paid a whole lot more money when litigation happens than I get from giving you proper advice for wills and powers of attorney. I'm speaking in jest, but there is some truth to it. Seeing a lawyer to have a will and a power of attorney done is not an expensive adventure, and it saves money in the long run. But yes, indeed, you can get them cheap on the internet. I can't tell you how strongly I feel about that being a big, big mistake. Yes, limits. And here's something that a lot of people don't know about the giving of powers of attorney. You can put in your power of attorney that it's only to be exercised if you lose your competence. You can't give instructions. Most powers of attorney, when given, they're effective from the moment you sign, and there's no limitation on it whatsoever. But you can tell the lawyer you want it only to be used if you're in a situation where you can't give instructions. You've lost your competency. So that's just something that most people don't know. I've talked about appointing 2 or more jointly, which I believe is very wise. And you can include in the terms of your power of attorney, for instance, if you're going into a nursing home, what nursing home you want to go to, or where you don't want to go. Because remember, you might not be competent at that point. What doctors you want, what treatment you want or don't want, all of this you can deal with in a power of attorney while you are competent, and you can give those instructions. Something that people ask me about, and it was just yesterday I was asked this question on fees. Under the power of the Substitute Decisions Act, which creates powers of attorney, an attorney can charge a fee for acting on behalf of the person they're representing. It's not that common, because normally a family member is appointed, and normally they don't charge a fee. But a fee could be charged, and there's a fee schedule in the Act if it isn't already agreed upon in advance. And if someone wants to give the power of attorney to a lawyer, they could actually specify in it that the lawyer is able to charge a full rate or a half rate or whatever the rate happens to be. So you can deal with the fees and costs of managing a power of attorney for you, and that can be done when you make your power of attorney. Enough about that. I want to talk about assets and how assets are held. Generally, when I deal with estates, we're dealing with 2 types of assets. One is property, like real property, real estate, a home, and the other would be bank accounts or some type of investment at a bank. Now, with the property, quite often what people do is they put property in joint names as joint tenants. That's a very standard practice between husband and wife, and it is very simple, because what happens when the first of the 2 die, the property automatically passes to the survivor. And there's just one document we have to register on title, and it's done easily, and it's cheap. So that's holding title as joint tenants. But I'm getting this question all the time, is, well, why don't I put our kids on title as joint tenants? And that way, when we die, then the property automatically goes on to the kids. Well, that's a bad idea, because income tax comes into play in that situation. And you can really cause a problem by putting title in joint names with your children. But certainly from, and again, we're talking about from the abuse point of view, be careful with that, because if that happens and there's other members of the family, I have seen a situation where the property was put in the names of the parents and one of the children. When the last of the two parents died, the child said, "Hey, it's all mine." And you imagine the brothers and sisters weren't too happy, and off they went to get their lawyers, and everybody spent money on lawyers, which is, again, I don't think that's a bad thing, but that could have been avoided, all right? Bank accounts, and this is what our friends at the bank see all the time. It's a very standard practice where an elderly person will have a child in the area, and they'll open a joint bank account. And it's very convenient, because that child can do the banking for the parent, and it's a very convenient thing to do. However, I have seen it, there's litigation on this, but I've seen it happen myself, that the joint bank account, the parent dies, the child says, "Well, it's all in my name now." And the brothers and sisters say, "Oh, Mom never intended for you to get the funds." And say, "Well, we'll put it in my name." So you get into that thing. Again, lawyers get involved. And I must say the law has changed now to the better, because it used to be that because it was in joint names, it was, I was going to say ipso facto, but it just was presumed, because it was in joint names, that it was intended that it go to the joint holder. The law is reversed now. If we have a situation like that with a parent and a child, that child must prove that the parent intended that the money be theirs only. So that's a good change in the law. Last thing I want to talk about is the Consumer Protection Act, and I have a real personal knowledge of this. Elder abuse, and I've seen it, the door-to-door salespeople take advantage of the elderly and sell them something. And you need to know, and this is good advice for everybody to know, that under Section 42 of the Consumer Protection Act, there's a 10-day cooling off period. And it means that the person who's contracted can cancel the contract without reason. They don't have to give a reason. There's 10 days, total cooling off period, and they can cancel that contract within 10 days. Within weeks, both my mother and my mother-in-law were approached by the door-to-door people on the hot water tanks, and talked them into changing their plan. And of course, the nice young folks at the door gave them all the best assurances. And in both cases, there was all kinds of problems afterwards with the canceling of the contract with the original supplier, payments that kept being taken out of the bank account. It just went on and on. And again, that's a situation where, personally, I saw these door-to-door folks take advantage and abuse of the elderly, and it wasn't too happy a period. And of course, then it falls on the children to clean up the mess. And you're not talking about big numbers, but to our mothers in this situation, it was significant and caused a lot of distress. Under the Consumer Protection Act, if you're talking about a situation where you obligate yourself, you say I'm going to send you $100 every month and whatever, there is under the Consumer Protection Act the right to rescind that contract also. It's called remote. If you're not, see what they're dealing with, if you go into a shop, it's presumed that you know what you're doing, you're shopping, you are making the move to go into a shop. Whereas door-to-door salespeople are coming to your door, or on the television, they're coming into your room through the television. And also, there's a whole section in the Consumer Protection Act dealing with the internet. Again, you're not going out, they're coming to you. So there is protection, for sure. If you get obligated into a long-term contract of paying money, then that's for sure is covered under the Consumer Protection Act. Well, if and that's very common, and the first question is, did the parent who made the change, did that parent have the competence? Were they able to give instructions and know what is happening around them? As lawyers, we're obligated to satisfy ourselves that that's the case. And I've had situations where I've just said, I'm sorry, I can't change your will or do things because, and it's difficult, puts us in a difficult position, but you have to make that call that this person is competent and knows what they're doing. And again, as I said, that's a very common situation. They get wheeled in by a child, and I make sure that I interview that person without the child